So let's take a look at the Kansas provision, and then we'll look at similar provisions from some other states. Let me see if I can make this a little bigger so it's easier to read. So the relevant part of this reads, a person is legally presumed to have a reasonable belief that deadly force is necessary to prevent imminent death or great bodily harm if the person against whom the force is used is unlawfully or forcibly entering or has unlawfully or forcefully entered the dwelling or place of work or occupied vehicle. Or, and this is the key of today's show, folks, or the person against whom the force is used has removed or is attempting to remove another person against their will from that highly defensible property. So, a couple things to point out here. You get the legal benefit. You get the benefit of this legal presumption of a reasonable fear of imminent deadly force harm under two alternative circumstances. One is that unlawful or forceful entering. That's one scenario in which you get the benefit of that legal presumption. The alternative scenario, because it says or between subparagraphs A and B, the alternative scenario is the kidnapping scenario, right? Someone's being removed against their will from the property. So two alternatives: unlawful, forceful entering, or kidnapping. Now, I will note one unusual aspect of this Kansas provision. Many states have similar laws like this. We're going to look at a bunch of them. Most of them say one of the conditions here for the legal presumption in the context of an intruder, not the kidnapping scenario, the intruder scenario, most states will say unlawful and forcible entry, not or forcible entry. Why do they do that? Most states want both the unlawful entry and the forceful entry because they're concerned about the scenario of an innocent intruder. Now, how could someone be an innocent intruder? Well, it's not as hard as you might think. So an innocent intruder is someone who's present unlawfully, but without malice. They're not there to do anything wrong to cause harm to anybody, to commit a crime. And an example might be a repairman who's sent to the wrong address. So a dishwasher repairman is told, hey, the Smith family needs their dishwasher repaired. They can't be home. They have other obligations, but they're going to leave the back door unlocked so you can get in and repair the dishwasher while they're away. And then they give the repairman the wrong address. He goes to that address in good faith. He goes to the back of the house. Sure enough, the door is unlocked, like he was told it would be, and he enters the home. Now, he's there unlawfully. It's the wrong home. He doesn't have privilege to be in that home. But he's not there with malice. He's not there to do anything wrong. And importantly, he hasn't entered forcibly. Now, many of the legislatures that have these legal presumption statutes do not want to provide the benefit of that statute against an innocent intruder. The reason they add forcibly as an additional condition, not in Kansas, but in most states, is because there may be an innocent explanation for why someone's unlawfully in your home, but there's no innocent explanation for why they broke something to get in. So if it was a forceful entry, that takes away the risk of the innocent intruder scenario. Kansas here puts this in the alternative. They either unlawfully or forcefully entered. So either one of those is sufficient to trigger this legal presumption. Is that better? Well, it's better for the defender. They have fewer conditions they have to meet. Is it morally better? Well, it's just a public policy call. I think, are you more concerned about the innocent intruder scenario, or do you want to give a greater benefit to homeowners being able to defend their homes against even innocent, unlawful intruders? So I just want to touch on that. Kansas is a little unusual in that it only requires one or the other, unlawful or forceful. But the real focus of today's show is that or between the two conditions, the intruder scenario and the kidnapping scenario. Either one, not both, is required. Either one is sufficient to trigger this legal presumption. And what does the legal presumption really do for you? Well, let's take a look. We all know I talk about the 5 elements of self-defense, right? The up to 5 elements that are required for a use of force in defense of a person to be lawful, or use of force against another person to be lawful. Innocence, imminence, proportionality, avoidance, and reasonableness. Innocence, that you're not the initial aggressor. Evidence that the threat you're defending yourself against is either actually occurring or immediately about to occur. Proportionality, that you're not using deadly force unless you're facing a deadly force threat. Avoidance, did you violate an otherwise existing legal duty to retreat before you used force to defend yourself? And reasonableness, were your both a subjective reasonableness, you believe you genuinely had a good faith belief in the need to use force in self-defense, and that belief is objectively reasonable. A hypothetical, reasonable, and prudent person would have shared that belief. The belief was not irrational, for example, or speculative. It was based on the application of your powers of reason to actual evidence, you were saying. So those are the 5 elements. What does this legal presumption of a reasonable fear of imminent death or grave bodily harm do for you? Well, it gives you 3 of the 5 elements, right? A reasonable fear of imminent death or grave bodily harm. Imminent is imminence. That you're facing a threat of death or grave bodily harm is proportionality. And reasonableness, obviously, is just explicitly stated in that presumption. Now, because we're talking about highly defensible property, let's presume your home, you also get the benefit of avoidance being satisfied under the Castle Doctrine. Every state has a version of the Castle Doctrine. Properly understood, what the Castle Doctrine does is that if you're defending yourself in your home, it relieves you of an otherwise existing legal duty to retreat. So avoidance is off the table. So it's 4 of the 5 elements of self-defense are given to you. And the truth is, the only one left is innocence. And if you're in your home dealing with an intruder who's unlawfully or forcibly entered, innocence is kind of baked into the cake, isn't it? So these legal presumptions in defense of your home are very powerful. And they make defense of home scenarios very difficult for prosecutors to go at. In part because, remember, the ultimate call on your use of force is going to be made by a jury. And a jury won't know anything about guns. They won't know anything about terminal ballistics. They won't know anything about the killer drill. They won't know any of that. They all live in a home, and they all emotionally know what it would be like to face an unlawful or forcible intruder in their home. So home defense scenarios are hard to screw up for the defender. Now, people manage to do it anyway, and this kind of legal presumption is really an explicit message to the jury because, of course, the jury gets a jury instruction on this law, and they're told there is a legal presumption that if these conditions are met, unlawful or forcible entry, or kidnapping scenario, that it's legally presumed these elements have been satisfied. Pretty powerful stuff.